It's time now for a look at the latest in local news. In the news, we continue covering the Tuesday press conference by District Attorney Keith Higgins, who spent a lot of his press conference attacking investigator Brad Kickleiter at the Wayne County Sheriff's Department, stating police misconduct and that he was dropping all charges against two defendants, John Yonkowski and Wendell Tank Lawson, who were both arrested and faced serious charges of rape. WIFO FM was at the press conference, and we already reported that Wayne County Sheriff Chuck Mosley attempted to attend that press conference but was denied access to the press conference. We also reported that Wayne County Sheriff Chuck Mosley still has Brad Kickleiter hired with the department, and that the sheriff still stands behind the officer despite the district attorney's attacks, saying he will not use Detective Kickleiter in any case moving forward, which involves over 40 serious cases here in Wayne County. Also told you that we were awaiting Sheriff Mosley's response to Keith Higgins' press conference, and we have it today. First, his response, and then we'll take a break and read a lengthy letter that the sheriff has sent to the district attorney. We advise that there is some graphic language in that letter, so if you have young children, you may not want to be listening to this broadcast. Again, we begin with Sheriff Chuck Mosley's response to the Tuesday press conference. Again, these are the words of Sheriff Chuck Mosley. I am writing this release to further inform the citizens of the Brunswick Judicial Circuit of my stance on the related cases and the allegations against investigator Brad Kickleiter. I have in the past refrained from discussing the case involved in public because of the hopes there could eventually be a prosecution. Since being denied access to the press conference and having to watch the recording of it, I no longer have any faith in prosecution. I no longer have any faith that a prosecution will occur. Even so, I will still attempt to refrain from causing the victims any further trauma than has already been caused by the release of their information by the district attorney's office. I in no way wanted a battle between the Wayne County Sheriff's Office and the district attorney's office, but after such a public attack, I have no choice. I watched in amazement as our district attorney displayed his PowerPoint and labeled the 14 written statements as false narrative. They should have been listed as similar transactions. There were no charges made on those statements because we are all aware the statute of limitations has ran on all of them. What they do show, though, are instances of similar actions on the part of one of the defendants in these cases. Again, the label of police misconduct was astounding, as well as the items listed that will be discussed in the attachments. The fact that the district attorney insinuated that either Chief Deputy Hargrove, Investigator Kickleiter, or I told the witnesses to include more information before they spoke to the GBI is appalling. Shame on him. I wonder if he considered they were compelled to be more descriptive because of his dismissal of the case previously. I've attached a letter I sent to District Attorney Keith Higgins in the morning of his press conference in an attempt to receive in writing documentation for his Giglio action against Investigator Kickleiter. I have the items listed that he discussed in his presentation, with the exception of one that he failed to mention at all. That exception is the writing of the search warrants, which Mr. Higgins may not be aware of. The search warrants that he insinuated contained false statements about the victim being naked were actually derived after being pursued by the Assistant District Attorney and two of his investigators. It was only after making at least two modifications to the warrants that the Assistant District Attorney arranged for Investigator Kickleiter to meet with the Superior Court judge to have them signed. During those modifications, the victim being naked was added at the behest of those reviewing the documents who had been present for the interview with the victim and the two corroborating witnesses. It was discussed that these warrants needed to be more descriptive because of the seriousness of the crime. Investigator Kickleiter made the changes as requested, and the end results are what they are. Since I have been made aware of the Giglio action, Investigator Kickleiter has been reduced to details where he's unlikely to be called upon to make an arrest or testify. This action by the district attorney will have long-reaching effects on our drug enforcement and on the drug cases which have already been made, which involve Investigator Kickleiter. One case in question involved enough fentanyl to kill 19,000 Wayne County residents, and now there's the chance it will be dismissed without the testimony of Investigator Kickleiter. As sheriff, I took an oath to enforce the laws of the state of Georgia and enforce them without malice or partiality. I have an obligation to ensure deputies under my charge are void of moral turpitude and are trustworthy. Since taking office, I have terminated employees for wrongdoing and prosecuted those who committed crimes. I will continue to guard against such transgressions and discipline those worthy of it. The fact that I don't believe Investigator Kickleiter was untruthful as being alleged, there will be no action taken until wrongdoing is proven. In advance, I would like to apologize for some of the language in the letter to Mr. Higgins. I want to speak in front of ladies in the fashion you will see, but was included because of necessity. Again, that from Sheriff Chuck Mosley. Again, we have the letter that he sent to Keith Higgins. We're going to take a break, come back with that letter. Again, we warn there is some graphic wording in the letter. So again, if you have small children or you don't want to listen to it, again, we advise you turn off the radio at this time. But we'll take a break, bring back the letter that Chuck Mosley wrote to Keith Higgins, have that for you right after this timeout. We continue with the coverage of the press conference by District Attorney Keith Higgins. Again, it has a response by Sheriff Chuck Mosley. Chuck Mosley wrote this following letter to the District Attorney Keith Higgins regarding the Giglio allegations on investigator Brad Kicklighter. It says, Mr. Higgins, I have not been provided anything in writing confirming my investigator has been officially giglioed. I've heard from a defense attorney with the public defender's office from the sheriff of the neighboring county and told verbally by you, but I still haven't received anything in writing. On October 27, 2023, when we had our meeting about the dismissal of the rape charges of John Yonkowski and Wendell Lawson, you lodged a veiled threat towards investigator Kicklighter that his credibility was in question. In this discussion, you mentioned you believed he was being deceptive in describing hydrocodone as an opium-based painkiller. Shortly after this conversation, investigator Kicklighter called the crime lab in Valdosta. I have a screenshot of the call log. This is important because he would later be accused of lying about making the call. The call was made because of your questioning his description of the substance in the undercover officer's system, opiates, oxycodone, and the hydrocodone found in the defendant's truck several days later after his arrest. Oddly enough, on January 17, 2024, investigator Kicklighter was questioned extensively by the assistant United States attorney about his being giglioed. This conversation was held because investigator Kicklighter was to testify on federal probation revocation in federal court. It struck me as odd those questions would be taking place, but then I remembered the suggestions from the October 27th meeting. I also realized this was before two GBI cases were delivered to you, one on January 19th and second on January 24th. The second case being a Pierce County investigation, which I find odd you would be interested in. It appears there has been more of an effort to investigate the investigator than to investigate the crime at hand. On February 6, 2024, the GBI delivered the case file to me. They advised me there was something in this case that could embarrass my agency. They relayed 4 things they believe Mr. Kicklighter was untruthful about. These 4 things were included in your 5 allegations and are discussed below. On February 12, 2024, you came to my office and spoke with myself and my Chief Deputy, Mike Hargrove. In this meeting, you discussed you had issues with Investigator Kicklighter's trustworthiness. You listed 5 issues in the GBI investigation revealed to you. They were: 1, Kicklighter misidentified oxycodone and hydrocodone. 2, you accused Investigator Kicklighter of lying by speaking to someone at the crime lab. 3, you accused Investigator Kicklighter about leading an undercover officer in writing her report because he wrote a timeline so the report would be sequential. 4, there was a report from the jail documenting injuries on the victim that were from a later date that was never used and discovered after the arrest. And 5, you said Investigator Kicklighter lied about the victim and the defendant being naked. Mr. Higgins, you told us during this meeting you would be preparing a letter that would have it to me either later that evening or the next day. I still have not received anything in the form of a letter. Because of these items in my eyes are inconsequential, I haven't taken any action toward discipline of any nature. The fact that someone has to be naked to get raped is an assumption that any reasonable person will make. That, combined with the language the victim provided in her statement, even further substantiates the assumption. Accusation 1. I will attach the manual form from the urine screen which reveals whomever Investigator Kicklighter spoke to told him the truth. In the urine screen performed by Wayne Memorial Hospital, hydrocodone will test positive for opiates and oxycodone. I feel sure the GBI was looking for inconsistencies, but they didn't ask the right questions for a true answer. I spoke with 2 individuals at the hospital, one which was the same person they spoke to. They confirmed the urine screen would show positive for opiates, oxycodone, if hydrocodone was in the system. This was an important part of the case in question since hydrocodone was found in the suspect's fecal several days later after his arrest. Mr. Higgins, you insinuated Investigator Kicklighter intentionally misled in the warrants by saying there was opium-based painkillers found in UC's system tested preliminary positive for opiates, oxycodone, but unfortunately both oxycodone and hydrocodone are opium-based painkillers. Accusation number 2. The accusation that Investigator Kicklighter lied about calling the crime lab was never confirmed because the employees did not remember speaking to him. However, Investigator Kicklighter has a screenshot of the call log on his phone, and I have a copy I will include where he had a conversation with the crime lab on October 27th that lasted 3 minutes and 26 seconds. What is amazing about that date is this was the same day you came to discuss your office dismissing the rape case and the reasoning. The samples of the drug screen were discussed this day and prompted the phone call. Accusation number 3, providing the timeline for the undercover officer. Investigator Kicklighter provided a 15-point timeline because the undercover officer said she didn't remember a lot of the details from the operation. The fact that she was drugged and had effects that hindered her memory, I feel giving her a timeline was only to ensure those points were documented. The undercover officer explained she remembered the incidents, but not in order which they happened. Investigator Kicklighter and Sergeant Arouse, the UC supervisor, were both present when the timeline was written and given to the UC. Investigator Kicklighter and 5 other officers were watching the live feed of the operation, including Sergeant Rouse, so the timeline was not manufactured as you would have led to believe. Accusation number 4, the mention of the injuries to the victim from an arrest booking report was irrelevant because the report was never used due to the dates being wrong. The document was mentioned in a supplemental after the dismissal because one of the jailers gave a statement about seeing the injuries and it was thought the dates were the same. When it was brought to the office, we discovered the dates were wrong. When this was realized, the supplemental had not been corrected. An additional supplement was added to the case file to correct the error, even though it was not considered in the investigation. Accusation number 5. Mr. Higgins, you said Investigator Kicklighter is being untruthful when he says in the warrants that the victim was naked. There were at the time 2 corroborating witnesses who described the victim telling them she woke up at the time of the rape with one of the defendants on top of her, raping her and fighting him. The GBI actually interviewed an additional corroborating witness that described the incident in the same manner. Investigator Kicklighter, being aware of the first 2 witnesses' statements at the time, I believe is explanation enough for a statement in the warrants. Investigator Kicklighter saying in a preliminary hearing that one of the defendants involved in the rape case was naked would be a safe assumption as well, but I believe he may have misspoke and said the victim said he was naked. To know the whole story, this defendant was reported to be standing between the victim's legs and saying, "Come on around here, Tank. I bet she's never had any black dick before." If these statements were made in a case which was unrelated to a sexual assault or rape, I would have issues with them. But the fact that this case is a rape case where the rape is the allegation, I truly believe any reasonable person would agree someone had to be naked. In conclusion, I want to address the history of these allegations. My investigator obtained the warrants for rape after hearing a conversation from the jail's phone system where the defendant and his son were speaking in code about the rape. In that conversation, they mentioned the defendant's big black friend. This conversation convinced me there was probable cause for an arrest warrant with all the other similar transactions we had reported at the time. I've heard probable cause defined in several different ways, but one most recently was in the Fannie Willis hearing. It was described as having 25% of proof beyond a reasonable doubt. I've always known it to be as knowing a crime has been committed, information compelling enough to convince a reasonable person the person being charged committed the crime. Before the warrant was served, John Koski also admitted in the presence of his lawyer the incident happened, but denied he had sex with the victim, but Tank did, and yet the case was dismissed. This Giglio action, and you're not allowing Investigator Kicklighter to testify, will ultimately result in the dismissal of approximately 45 cases and 2 federal investigations. If these actions were intentional in nature or malicious, I would be the first to take action against Investigator Kicklighter. With the items as they have been described to me, this is a miscarriage of justice. An officer of an agency should at least have some sort of due process or recourse when accused in such a flagrant manner. It is also unheard of not to at least do a follow-up to confirm there isn't a misunderstanding when such actions are going to be taken. But the GBI only called Investigator Kicklighter about the call to the crime lab and who he spoke to. It is my belief you got embarrassed by the protest by the dismissal of the rape charges, now have begun to search for a way to clear your office and place blame elsewhere. I'm writing you this letter to make it clear I need some kind of documentation to explain why our prosecuting attorney's office is unwilling to use one of our hardest working investigators. All the issues you mentioned as listed above are arbitrary and capricious in my mind, especially when approached from the mind of a prosecutor. Now a defense attorney would think differently, but that's not supposed to be what we are. We, the sheriff's office, are supposed to be the finders of facts, and your office is tasked with the prosecution of the cases. The lies of the defendants are supposed to be weighed and considered also, but it appears that an investigator misspeaks or misremembers. It's a cardinal sin. I'm looking forward to a written response. Once again, that's the letter sent from Sheriff Chuck Mosley to District Attorney Keith Higgins after Keith Higgins' press conference on Tuesday. One final note is now the sheriff has responded. None of this is good for anyone. Not the district attorney, not the Wayne County sheriff, who both are currently running for re-election. The district attorney and law enforcement are supposed to be on the same side, fighting crime and locking up criminals. But as the sheriff points out in his letter of response, law enforcement feels the DA's office is more interested in prosecuting the investigator Brad Kickletter than they were in prosecuting the two defendants. We report on this case from the beginning, and we reported yesterday, and it bears repeating again. This case had 3 bond hearings in Wayne County Superior Court, where evidence was presented by the district attorney's office in Superior Court, in which the district attorney's lead prosecutor, Tiffany Montenegro, argued in court, called witnesses to the stand, and asked that bond be denied not once but twice, and told Superior Court judge that the state had 11 sworn affidavits from women who claimed that they were drugged and assaulted and came forward after the arrest of John Koski. The judge sided with the district attorney's office and denied bond not once but twice. The next step again is to present that evidence and findings to a Wayne County grand jury and let them say yes or no that the case should proceed to trial. But again, that never occurred in this case. But that would have solved all of this. If a grand jury said enough evidence was there to go to trial, so be it. If they said not enough evidence to go to trial, again, the issue would have been settled once and for all. But now all this has become a political football between the DA's office and the Wayne County Sheriff's Department, and law enforcement in general. Believe me, it's not good for anyone. Again, we'll continue to follow the story as it develops, but again, that was a response today from Sheriff Chuck Mosley to the press conference held Tuesday by District Attorney Keith Higgins. We'll be back with some final news notes after this word from our sponsor or other commercial messages, so please stay tuned. Final notes and news this Saturday, the Wayne County Farmers Market, the annual barbecue and blues event, gets underway at 6 p.m. tomorrow evening. Tickets are $25 for adults and children under 12, $15. Music by Jeff Chandler, Chloe Price, and stand-up comedy by Briggy. Again, if you need more ticket information, market manager Amanda Ryan is the person to call, 561-578-969. I believe that's part of our Bitchin' and Bob show this morning to talk about the event on Saturday. Also, this is an election year. The primary date is May 21st. Again, the registrar's office says the last day to register to vote to be able to vote in these primaries is April 22nd. If you need more information, they ask you to contact the registrar's office at that number, 912-427-5950. Chamber of Commerce hosting their post-legislative luncheon at Coastal Pines Technical College that day, Tuesday, April 23rd from 11 to 1. Everyone's invited to come get a recap of the session from our local representatives, State Senator Blake Tillery, State Representatives Buddy DeLoach, and Stephen Meeks. Tickets are $30 for members, $40 for non-members. Everyone's invited. If you need ticket or information, call the Chamber at 912-427-2028. Again, the Wayne County Board of Tourism Spring Fair winding down this weekend. And tonight and Saturday, the time from 6 to 11 costs $15. That includes all the rides. If you need more information, call the Wayne County Board of Tourism office, that number, 912-427-3233. And a community-wide blood drive set for Monday, April 15th from 1 to 6 p.m. at Calvary Baptist Church Gymnasium, 415 East Cherry Street, sponsored by the Jesup Shriners Ladies Auxiliary. Once again, to schedule an appointment, they ask you please visit the website, redcrossblood.org, enter Jesup to schedule an appointment. Walk-ins will be welcome. That's going to do it for latest in local news. Sports comes your way in a few minutes. Bob Morgan, have a great day.